Argument like in the term before you make a ruling, that's correct.
Yes.
The reason why state recommendation is what it is because he was on probation for a 2018 offense of aggravated assault with a deadly weapon. 3 years later, picked up misdemeanor assault, bodily injury, married co-had with unfortunately not for that victim of the property, but it was a different victim.
All right, so I will listen to what you have to say, but let me explain something to everybody.
Yes.
Y'all are only going on 14G. And that's the only thing that I have before the court. Now, I see the motion to revoke, and I see there is a violation of number 1. There's a violation of 14U. But the only thing I've been presented with is a violation of 14G.
Yes, sir.
And he's on deferred adjudication. And 14G, and if there's a disagreement on the facts that I've been given, let me know. Facts that have been given to me about 14G is he didn't complete his Batterer Intervention and Prevention program. There were 12 classes. He did 11. They kicked him out of the program because he didn't have money, and they're waiting for the balance. Then I guess he can take the final 12. That's what I'm dealing with. If you want to go on other violations, I'm willing to hear that. You all have just gone on 14G. And what I have on 14G, I don't, it would not be appropriate to revoke someone who's done 11 of the classes. They only have 1 remaining. And the reason why they didn't do that 1 was they didn't have money to pay for it. Now, if somebody wants to present some information to me that he could have paid for it, he just chose not to. He won the lottery, he chose not to use it for that, he chose to do something else, I'll hear that. But I'm just here for 14G.
Judge, he did not win the lottery. In addition, Judge, he was doing really well last year and a half.
That lottery comment isn't sarcasm for entertainment. It's legal framing. The judge is signaling something important. Inability to pay is not the same as refusal to pay. Courts cannot revoke someone just for being broke. The state would have to show he could pay and chose not to. That distinction is everything.
Now, his first MTR, he's on the term, he's employed, he has a CDL, he's a truck driver. He hasn't tested positive for any substances. He's tested all the time and come up negative. If you test today, Judge, if there was any doubt, he would come out negative. He's been in jail, custody for about 30 days already, and we believe that if he is motivated back on deferred, place him back on deferred, Judge, he's going to do anything the court wants him to do. If you want him to do the DIP course all over again, more than willing to do it.
Well, I don't think it would be appropriate to redo the entire course when he only has 1 class remaining. Is there something else to say?
One more additional argument, Your Honor.
Yes.
The violation of the book that Your Honor had occurred over a year ago, and as Mr. Dale wanted to find his gainfully employed and trucker, which I would assume pays well, and he's had a year to try and take care of that particular non-issue has failed to do so at the point in time. Additionally, Your Honor, if Your Honor does not feel like
Now the prosecution shifts strategy. They're arguing this wasn't sudden poverty. This was a year-long failure to fix the problem. That's subtle but powerful. The question becomes, was this hardship or procrastination? And judges care deeply about effort.
revocation is appropriate, he would, and if Your Honor is considering continuing revocation, he would ask that Your Honor add a jail sanction to his probation that begins.
All right. This is what I can tell everybody. There's one outstanding class. Am I correct in that?
Correct, Judge.
And this motion to enter adjudication of guilt and revoke community supervision was filed on June 12th, 2025. And we'll have to look in to see when he was actually arrested on this. Sometimes motions to enter adjudication of guilt, they're signed, they're filed, and then if he was in Harris County, he were arrested in Harris County, he would have needed to be brought back to Bexar County. So, these are your choices. You know yourself better than I do. You know yourself better than your counsel does, the state does. I do realize that the state is only proceeding on 14G. I don't understand about this thing from North Carolina on June 8th, 2025, but these are your choices. I can continue you, or I'll sentence you to 2 years in the prison. Those are your choices.
Well, we need to run.
Well, I can tell you right now, based upon what's in the motion to...
And here it is, the courtroom fork in the road. Continue probation or 2 years in prison. No jury, no dramatic deliberación. Just one judge and one decision. This is the quiet intensity of revocation hearings. They move fast, but the consequences last years.
Revoke, maybe truck driving is not because the violation, and I'm not considering the state didn't present any information, but I said where it's alleged to have been committed in North Carolina, and I think that's related to he's driving his truck in North Carolina, so maybe he should not be allowed to drive in other states.
Absolutely. Now, I've had a discussion with my client, Your Honor, and if he plays back on deferred, he knows that, he's in trouble again. He's back to turn up 187, so he understands that, bad consequences. So, but he has reiterated too, he does want to be placed on deferred, back on deferred, and he'll do whatever court.
Well, if he wants to be continued and deferred and continue to drive a truck, I'm not going to allow him in the state of North Carolina.
And he'll agree to that.
Is there anything else?
If Your Honor would, as you just mentioned, you can see it by evidence of the number one. Just consider the fact that even after doing 11 of the 12 bit courses, that number.
Well, I don't know if that rises to the level of preponderance of evidence, which is the standard of proof in motions to revoke. I don't know if that's something that rises to the level of proof beyond a reasonable doubt. If it's for a jury trial, I just see that there's something in North Carolina.
That needs to be, Your Honor, if you're willing to look and go over and the
Judge, I'm objecting to it. Waive the number one allegation. That's something for the court not to.
That'll be sustained. So I'm to deny the motion, alternate amendment conditions. There's to be no contact with the state of North Carolina.
That right there is a major procedural win for the defense. The state tried to slide in additional allegations after choosing not to proceed on them. The judge shuts it down. In revocation hearings, the rules are looser than a trial, but they still exist. And here, the court draws a line.
Unless he's ordered to be there.
Okay.
Legally ordered to be there. Not by your employer says you need to drop off a load in North Carolina. You're not allowed in the state of North Carolina unless in the state of North Carolina they have a hearing for you in a court of law. Is there any other conditions you're requesting?
The defendant as well are intended in probation to have no contact with Tamisha Singleton. And that's, if I can spell it for the record, Your Honor.
So Tamisha?
Yes, T-A-M-S-H-A, and then Singleton.
No objection to that.
All right. So there's been no contact with Tamisha Singleton, no residing with minors, no unsupervised contact with minors, and you're going to restart the bid course. And Ms. Abrams, that needs to be restarted within 15 days. Is there anything else?
No, Your Honor.
All right, we can go off the record. Here's the thing. I didn't really consider that number one. because the state didn't proceed on the number one. But I did allow you no contact with Carolina because, of course, you see things with alleged have been committed in North Carolina. It appears that you are a person who should not be in a relationship because you don't know how to keep your hands to yourself. So you need to work on self and figure out why you may or may not, because I don't know anything about that case, are abusive towards people you claim to care about. Because at some point in time, you're going to run across somebody who's somebody's brother, mother, or sister. It's going to be very upset that you're mistreating their relative, and they're not going to tolerate that. And if something were to happen, you know what people are going to say? Oh, well, you should have kept your hands to yourself. So I don't know why you can't do that.
Notice what's happening now. The judge already denied revocation. Prison is off the table for now. But this speech, this is about accountability. The court is making something very clear. Second chances don't erase patterns. And the subtext here is heavy. The next time this lands in front of this bench, the outcome may not be this forgiving.